What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. If you're watching this video, you may be doing so because you watched my last video, where I talked about how Chille DeCastro's misinterpretation of case law, specifically Houston versus Hill, is at least partly responsible for the growth of his confidence in believing he was justified and had a legal right to interrupt police officers in the course of their duties. Now, first, I need to make an acknowledgement of a mistake and a correction. During my last video, I said that Chille had been convicted on disorderly conduct charges. That is incorrect. He was actually convicted on two separate misdemeanor charges, one of obstructing a public officer and one of resisting a public officer. Now, after I published the video, I had several people in the comments ask me to go over what I think the judge and the officer got wrong. So in today's video, I'll be covering what I consider to be the wrongful conviction of Chille for the two offenses of obstructing a public officer and resisting a public officer. Now, the videos I'm using come from the YouTube channel Our Nevada Judges, and I encourage you to go over there and watch the channel, watch the trial video in its entirety, and then you can judge for yourself. Now that we have that out of the way, let's look at the arrest video, and then we'll go over the reasons I believe he was wrongly convicted. Let's check it out.
Don't engage my driver, back up. Hey, back up. Back up. You're not involved. You can tell me you need to stay away from my driver. Back up. Back up or I'm going to detain you. For obstructing. Get away from my car stop. Okay. Listen. She deserves privacy. This is not your business. Okay. You're being detained right now. Come over to my car. Come over to my car. Come over to my car right now. No, come over. Listen, I am going to put my hands on you. No, you're not. Control officer on the left. I got to make sure that you guys get my people on the phone. I have an obstructive wheel here, so no picking. So you can't just stop. Come over here to my car. Come over here. I need to do this obstructive. No, come over to the car. I'm going to grab you. You are going to go to the ground. Listen, you are detained right now. Get your supervisor out here. You're not going to get a easy way. I just need to
Okay, here's a perfect example of what I was referring to in my last video when I talked about Chille's misunderstanding or misinterpretation of case law. You hear him making a comment about how the officer releasing the driver and ending the stop is a violation of the Rodriguez decision from 2015. If you've watched much of my content at all, you know that we talk about Rodriguez and Mims a bunch on this channel because both of them are extremely relevant in considering the scope of police authority on traffic stops. In my opinion, there wasn't a single issue related to Rodriguez in the officer choosing to end the stop of the driver, let her go, and then deal with Chille. Remember that what Rodriguez stands for is that the police can't extend a traffic stop unreasonably in order to conduct investigations other than the original mission of the stop. The defendant in Rodriguez was issued a warning for a traffic violation, and then the stop was basically over. The officer, though, refused to release Rodriguez because he wanted to hold him back for a canine sweep. And so even though it was just a few minutes, making him wait for that canine sweep, the court said, look, you didn't have any reasonable articulable suspicion outside of the original traffic stop in order for you to justify holding him to wait for the canine sweep. So any amount of time is unreasonable where you don't have reasonable articulable suspicion to support the detention. So again, Rodriguez is about unreasonably extending the stop to do other stuff that's not related to the traffic infraction. Here, the officer just ended the traffic stop and he chose not to cite the driver because he decided to deal with Chille instead. So ironically, the only actual Rodriguez violation that might have been at play was caused by Chille himself, because that driver ended up being detained a little bit longer for a reason that had nothing to do with her traffic violation, dealing with Chille. And so by choosing to let her go as he pivoted to dealing with Chille, the officer was actually closer to adhering to the holding in Rodriguez than he was in violating it. Now, back to the video.
You're being detained right now. Turn around. Get your supervisor. Stop.
Now, at trial, Officer Bork ended up being able to testify to a bunch of nonsense about a 21-foot safety rule. Let's take a look at that testimony.
In the video from your body-worn camera, it shows, you know, the state of your stop with the Hyundai driver. Do you recall that?
Yes.
Okay. And at some point prior to you making contact with the defendant, you noticed him kind of recording further away from the vehicle, correct?
Yes. Yes.
And at that point in time, you didn't have a problem with that. You didn't really approach the defendant yet, correct?
Correct.
It was when he started making contact with the driver, your stopped driver, that you approached him and asked him to back up.
Yes.
And at some point in time, in the video, it's recorded, you told him that he is allowed to record, but he just needed to back up.
Yes.
Okay. And what was the reason for you trying to maintain, one, the lack of no contact with the stopped person, and two, trying to gain distance between the defendant, yourself, and the stopped driver?
My first intention is I wasn't trying to delay my traffic stop any longer than it had to be. I was trying to make it as short as possible for the driver. And then the second was for officer safety. What we're taught in the academy is that for a normal human's reaction time with open ground, anything within 21 feet, that suspect would be able to charge an officer without them being able to react in time.
All right. And at that point in time, you were the only officer present, correct?
Yes.
Okay.
Okay, so let me give you guys a little bit of insight on this issue. There is, in fact, a 21-foot rule, but it really has nothing to do with how close you allow a bystander to get to you as an officer on a stop or in an interaction with the public. The true 21-foot rule is related to the reactionary gap that exists when dealing with a person with an edged or impact weapon in a deadly force scenario. Without getting too far into the weeds, the rule is basically this. A person with a knife or other edged or impact weapon can close the distance and use that weapon against an officer from a distance of 21 feet before the officer can effectively draw their weapon and fire. This was based on experiments done informally by a police lieutenant named Dennis Tueller more than a couple decades ago. I've actually linked an interview with Tueller in the description if you guys are interested in watching it and learning a little bit more about this. But in his experiments, it basically started as an experiment on the range. But in the video, Tueller basically explains that the experiment got started because they were on the range among a group of academy classmates, and then one of them asked the question, look, if a person were to charge you from this distance, and 7 yards or 21 feet is the distance in question because that's a typical firing line distance in firearms training. And so the question was posed by one of the academy cadets as to whether an officer could react and effectively draw and fire their weapon from 7 yards or 21 feet away from an unexpectedly charging suspect. That's where it came from. So it has no legitimate application in law enforcement training to how you might deal with someone who's even considered an agitator on a traffic stop. This was just some garbage that was likely concocted in the trial prep process between the officer and the DA, Agnes Botello. Now, this represents one of my biggest pet peeves with attorneys, regardless whether they're DAs or defense counsel. They don't know what they don't know, and they don't even seem to be curious about it. This is the reason I get a chuckle out of people when they suggest in the comments that they'd never hire a lawyer who used to be a cop. Well, I mean, okay, but then you're going to miss out on hiring someone who was trained on the 21-foot rule and has trained other people on it and who can effectively dismantle the officer's credibility as it relates to that rule and stop the officer from improperly trying to conflate deadly force in an edged weapons training scenario with the threat level imposed on an officer by a person who's filming a traffic stop and has declared himself to be a journalist. Or you might miss out on someone who knows how to effectively question an officer about a pacing violation, or who knows how impossible it is to establish a reliable pacing situation anyway, or the procedures an officer is supposed to follow in checking for calibration on a radar unit, or what a Doppler tone sounds like, or how you're supposed to visually estimate the speed of a vehicle and then match it to a Doppler tone. Whether or not it makes a difference if an officer is using radar as opposed to LiDAR, and how wide a radio wave is and how it takes up the whole roadway as opposed to the 36-inch width that would be probably like the widest that you'd get on a LiDAR tool when you're trying to match it to a particular vehicle. The point is, the value of life experience cannot be overstated. And life experience and understanding understanding police culture and how it works is an invaluable tool in a lawyer's ability to deconstruct a case. If they have a solid understanding of how something was constructed, they'll have a solid understanding of how to deconstruct it. Please understand that the attorney who understands the underlying subject matter better will be able to craft more relevant questions to bolster the persuasiveness of their argument. Most people are mystified by police culture. Your lawyer has to have a good understanding of it in order to demystify it and make it clear to the trier of fact, and to be able to highlight what you need them to understand about the case. Most DAs don't know this stuff either, and they'll just try their best to sell it like Agnes Botello did here. And if your lawyer doesn't understand what's being discussed or which questions need to be asked in order to impeach the officer on it, you're going to end up losing on those points, and the judge will consider that the officer is almost an expert and the only one in the courtroom who understands what he's talking about. So if Chille's trial attorney was ineffective, I can say that it was in this way. He missed some huge opportunities on cross-examination by appearing to just not understand the scope or different elements of police training. And because of that, he allowed the officer to establish himself as the only one who knew anything about the training, thus allowing the state to carry the day with this nonsensical notion that police officers get a 360-degree, 21-foot safety bubble. Relevant questions about this might have included, isn't the 21-foot rule related to an encounter where the officer is caught off guard by a person with an edged or impact weapon? I mean, surely you're not suggesting that you're trained to assume that everyone is a deadly threat and you need to keep a 21-foot distance between you and them. And you'd agree with me that the actual training is related to how to navigate a potential deadly threat, specifically with a person utilizing an edged or impact weapon, and not how to interact with the public or a person filming a traffic stop, wouldn't you? So how many times, officer, roughly would you say that you've been recorded in this manner by people? Any of them try to attack you with edged or impact weapons? Now, were you able to see Mr. DeCastro's hands during your interaction? Well, could you explain to the court why it might be important for you to see his hands? Isn't it true that it's pretty accepted among law enforcement that if you can see a person's hands, there's a reduced likelihood that that person can produce a hidden weapon and attack you with it? In fact, doesn't the rule go something like this? If you can see their hands, they can't kill you with them? And you could see that Mr. DeCastro was clearly holding a cell phone and narrating a video about your traffic stop, right? And that was from the beginning of your interactions with him. And then after you engaged with him a little bit, he actually produced a second cell phone in his other hand, right? Have you ever seen a video of an officer being attacked? Officer Bork, how many times would you say you've seen those? Have you ever seen one where the attacker was holding a phone and narrating a video? Okay, so you've never seen that on video, but what about your personal experience? Has it been your personal experience that you've been attacked by a person holding one or more cell phones? Doesn't it sort of reduce the likelihood in your mind that a guy holding a cell phone filming a video is going to harm you? Now, Michael Mee, the attorney of record here, appeared to head in that direction with his cross, but he never really got there. Bork appeared, at least to me, to be improperly coached by the DA. I say that because on the video, he clearly expressed that he was concerned for the privacy of the driver. He completely changed his story on the stand. Remember in the video, he said, "Get away from my driver, she has a right to privacy, this is not any of your business." On the stand, he admitted that he understood she didn't have an actual right to privacy in public, but he intentionally asserted that to Chille because he could tell that by continuing to do the same thing and tell Chille to back up, that wasn't going to work. So he had to use a different strategy, and that he probably had a better chance of appealing to his humanity and asking him to consider someone's privacy in public. Remember by this point that Bork has already testified that he never got the opportunity to tell Chille how far to back up because Chille was so argumentative. He suggested that he had to take control of him before he could tell him to back up the 21 feet or past the tractor trailer or whatever he said he would tell him to do. But he did have time to psychoanalyze Chille and determine that he was the type of person that could be psychologically manipulated using a different justification for asking him to back up. I mean, it took me exactly 2 seconds to determine Chille couldn't be reasoned with psychologically. By the way, you can tell by his videos that it takes most cops who interact with him about the same amount of time, because most of them just eat the loss and choose not to engage with him, probably under the same diagnosis. But this guy, this Brandon Bork, he's a regular old Jordan Peterson. He's going to appeal to him psychologically and employ a different strategy to sort of manipulate him. Get the fuck out of here with that. I don't buy it. He sounds like a guy who was advised by the prosecutor and during that meeting learned for the first time ever that there was no right to privacy in a public place, and further advised pursuant to that by the prosecutor that he's going to need a different explanation as to why he said that on the scene. Now, Mee did have a period of effective questioning where he went on to ask Bork why he didn't engage Chille until he noticed he was talking to the driver, but he missed a huge opportunity here. He didn't emphasize that the words were the only threat. I might have asked, so did Mr. DeCastro change his position when he began engaging the driver? No. So how far away from her was he when he began talking with her? And how far away were you? Were you able to hear from the inside of your car what he was saying? No. So it's not like his words were so loud that they kept you from being able to like hear dispatch, run your checks, write a ticket, anything like that, right? You're neutralizing the notion that he was intentionally trying to keep him from doing what he was supposed to do. And Officer Bork, you would agree that he wasn't talking to you at this time, right? So again, how would they prove that he intended to hinder or obstruct the traffic stop if he wasn't even talking to the officer? So Officer Bork, you'd also agree with me that at that point you were focused on the driver and that he was mostly trying to give the driver information that they may or may not have been interested in. And he wasn't doing anything that kept you from doing the ordinary stuff you do to conduct the tasks associated with a traffic stop. And again, you didn't engage him before he talked to her, right? And your testimony is that he did not move forward in the process of him talking to her. So what you're saying is that the sheer fact that words were being exchanged between the driver and Mr. DeCastro is what elevated him from a normal person filming a traffic stop whose proximity to the stop hadn't changed, by the way, based on your testimony, to a potential deadly threat who, pursuant to your training, can get the drop on you if they're closer than 21 feet? Is that what you're saying? So just for the sake of clarification, is it 21 feet from you that your protective bubble extends, or is it 21 feet from the driver? Because at the time that you told him to back up, he was well beyond 21 feet from you. I mean, you were in your patrol vehicle and the driver was ahead of you in her vehicle, and he was a third of the way through an 18-foot parking spot about 10 feet from the driver. So he was a good 21 to 25 feet from you, right? And it was actually you who began to engage him and close the distance such that you eliminated the 21 feet between the two of you. So how is this really about officer safety? Also, are you saying that it's codified in official Las Vegas Metro police policy that there's a default 21-foot radius of protection to be established around any officer in any interaction? Or is that at the individual officer's discretion? Are you saying that you personally, after having the 21-foot rule training related to edge weapon defense and deadly threats, have decided that for your personal safety, you need to create your own 21-foot rule? I ask because it seems awfully strange to me that as we watch this video, it was in fact just words that caused you to take action and engage the defendant. And prior to you trying to arrest the defendant, he didn't do anything but say things back to you. I mean, you just acknowledged that you didn't see him as a threat from 10 feet away until he exchanged words with your driver. And then you observed him tie up both hands with cell phones and magically somehow become more of a threat after he said something insulting to you. Do you consider that a coincidence? Now, I may have not done any better than Michael Me. I'm not trying to be super critical of him. I'm just saying if he missed a chance, that's the chance he probably missed. Now, there is hope for Chille because the Nevada Supreme Court of Appeals looked at the statute he was arrested for and interpreted it for the first time in 2024 in the case of Wilson versus the First Judicial District Court. The opinion is long because the statute had been on the books since 1911 and had never been interpreted by the courts. So regardless of whether this conviction gets overturned, the officer won't be held liable for the statute that hadn't been interpreted prior to his enforcement of it. But the court basically interpreted the statute to mean that in order to be guilty of obstruction, the conduct of the defendant had to be limited to fighting words and physical conduct, and they even applied a specific intent standard that said that the fighting words and physical conduct had to be specifically intended to hinder or delay the officer to obstruct the investigation. That means that the state not only has to prove your conduct was physical or fighting words, but it also has to prove your state of mind to the extent that they must show the intent was to obstruct the officer by hindering or delaying. Chille made it clear, as he normally does, that he feels people were victims of the police and that he's recording for their safety and for transparency, regardless of the fact that we all might think it's obnoxious in the way that he does it. Bork attempted to arrest him before anything more than that happened. While the officer won't be held liable, the judge might be overturned here because she should have arguably been aware of it. This is likely another huge opportunity missed by trial counsel. He had the opportunity because this thing was set for trial like 4 different times. If you go through Our Nevada Judge's YouTube channel, you can see update after update where they've changed the trial date multiple times. He had plenty of time after February to find this case and brief it to the court to at least put the court on notice that this case had been decided in the way that the law was interpreted was favorable to his client. I mean, how do you not know that a case was decided a month before your trial that limited the application to statute your guy was arrested for to fighting words and physical conduct? That's a huge thing for somebody who's arrested over just words. Now, the court in its opinion on Wilson did specifically say that failure or refusal to follow a lawful order could be grounds under the statute if you can prove the existence of specific intent to hinder or delay. So that's why bringing out all this stuff on cross is so important. The lawyer has to be able to show that the initial conduct of his client was not obstructive because it lacked specific intent, it wasn't fighting words, and it didn't have a physical component to it other than being within what the officer considered to be his 21-foot bubble, which is pretty unreasonable. He has to be able to show that the officer was attempting to make a false arrest based on his arbitrary safety bubble. It's the only way to make the argument that the order was unlawful, and that's the only way Chille could mount a defense for the second charge of resisting, is by showing that the original arrest was unlawful. As far as the judge goes, one of my fellow attorney subscribers, Tanya, from the channel Esquire Audits, suggested to me, in a less colorful way admittedly, that I might be very careful not to blow out my knee jumping to conclusions that the judge in this case was biased. Now, she has a valid argument, but this is my reasoning. I'd like to see her record of incarcerating people on this charge before I could be really sure. But I'd be willing to bet that she's never given anybody stacked 90s for 2 charges arising out of the same incident and putting them in jail for 180 days for this, especially where the DA was asking for a suspended sentence on probation. I'd be willing to bet she hasn't even given anyone else concurrent 90s to serve on those charges where the DA was asking for a suspended sentence on probation. Now, in my neck of the woods, there's like 7 or 8 factors the judge has to put on the record in sentencing before consecutive sentencing out of the same incident would be upheld. But Nevada has an insane amount of discretion given to judges in consecutive sentencing. The general rule is that concurrent sentencing is favored if you did one series of things in the same incident. But I looked at like 100 cases in Nevada and they were all upheld because the standard for overturning them is so high. You basically have to show, best I can tell, that the judge used impalpable, defined as hard to understand or comprehend, or highly suspect evidence in making her sentence determination. The judge here found a middle road, used evidence in the record to justify her sentences, and I don't suspect that they're going to be overturned. Due to the wide discretion the appellate courts have given judges to determine whether consecutive sentencing is appropriate under the circumstances. Again, this is something somebody claiming to be a constitutional law scholar like Chille does should have known. Knowing that a jurisdiction gives judges very wide discretion in sentencing is kind of important when you're deciding where to go be an agitator to police officers. He may have chosen not to be such a provocateur in the courtroom had he realized what could happen to him. No one can make the argument that Chille's physical conduct here, though, was particularly egregious. I don't think this was an appropriate sentence under the circumstances. All he really did was act like he normally does and be obnoxious. He wasn't a physical threat to the officer, and the officer said that he didn't think Chille was trying to hurt him and didn't charge him with assault or battery on a police officer or whatever. It's really the speech that the judge found abhorrent, and the speech is all that's constitutionally protected. And that's why, regardless of how you feel about Chille, whether you like him, whether you don't, this is something we should all care about. Because next time it might be our speech that's improperly converted into a physical threat to be used to incarcerate us. In closing, I think Chille's conduct here was not illegal. I think he got arrested for contempt of cop. I think Brandon Bork is a chicken shit and that he perjured himself on the stand. I think there's a decent chance that the prosecutor coached his testimony. That's a suspicion of mine based entirely on the change in testimony and then this sudden epiphany that he had that people don't have a right to privacy in public, despite the fact that his only stated concern on scene was her privacy, and the issue was that he thought it wasn't Chille's business. I'm open to the possibility that I'm wrong about that, but that's what I believe is the truth. I think Judge Zimmerman didn't like Chille and sentenced him according to her personal feelings about him and her offense to his protected speech. I think she also wasn't truthful when she said that she didn't sentence him for the way he acted in the court and the way he treated the marshal. I believe that's exactly what she sentenced him for. And again, I'd be open to admitting I was wrong if I could see how many other people she sentenced accordingly. I expect more than that from a judge. Their job is to remain impartial. Justice is not served by a nonviolent person saying things we don't want to hear, clogging up a jail cell for 180 days. Now, unfortunately for Chille, after watching Patrick Darcy's breakdown of the appellate brief, which I hadn't seen until I saw his video yesterday, I don't think that the appellate brief that his attorney turned in is going to be very helpful to him on appeal. And as Darcy suggests, it looks like Chille was controlling the tone of the appellate brief because he was more interested in outlining the parallels in his plight to that of George Floyd and in basking in his perceived martyrdom than he was advancing relevant appellate issues. By the way, y'all should check out Patrick Darcy's page. He's a Georgetown law grad. He's very, very funny, has a lot of good stuff on his channel. He's a very smart guy. I'll leave a link in the description. And thanks again to Tanya from Esquire Audits for telling me about Mr. Darcy. One final note to my Chille fans and probably a good 50% of my audience. I realize that a good portion of you guys subscribe to this rigid, this is the way it should be. They're public servants and they should never do this or never do that sort of way of thinking. And I don't necessarily disagree with you. Let's say that you're 100% right. What happens next? In your mind, it's this black and white thing where everything is easily understood. But here's the problem. Literally every question in the law is, it depends. There is nothing, and I do mean virtually nothing in the law that's black and white. Everything is fact intensive. So if you can't admit objective truth, and if your position is based on something more akin to how you feel than it is to objective truth, how do you get closer to what you want? And you also realize that the people who disagree with you also think they're right and that you're wrong, don't you? And their position is also controlled more by subjective feelings than objective facts as well. So who's right and who's wrong? And how do you find a middle ground? Especially when neither of you acknowledge the existence of a middle ground. It's either all your way or all their way. Who wins the tug of war? The one with the most influence wins. And the way you get influence is by being able to have a conversation where you're able to persuade people and convince them to consider another way of thinking. Hopefully yours. And you absolutely cannot accomplish that if you can't tolerate their ideas. And there's no room for a discussion with you related to the possibility that you could be wrong. I take the position that I can learn something from everybody. Now, whether you agree that Chille was wrongfully convicted or whether you don't, it will be interesting to see how this plays out and what his appeal process will bring about. I'll be sure to update when something of significance happens. That's all for this one, guys. Thanks for sticking it out. Please remember to like and subscribe and leave a comment on the video. Watch a couple of the other videos on my channel and leave a comment there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.